They say justice is only for those who are privileged. But Judge Stevens will surely change your mind as he serves these criminals what they deserve without picking favorites.
Normally, you pay a price when you're shooting people.
You will not expect what this lady just did. In fact, even Judge Stevens was shocked after reading the court documents, which revealed that the defendant committed not just one, but a total of 97 criminal offenses.
96 criminal disposition.
And yet she still dares to ask for probation.
So please, please.
But Judge Stevens knew better and called her out for her action.
No, ma'am, not under this situation.
Emphasizing how the defendant would even bring specific equipment as if she wanted to be ready, like a Girl Scout. In the end, Judge Stevens did what was necessary to punish her without hesitation.
So she's looking at no less than 180 days up to 15 months defense.
I know that the criminal history portion of this report has a lot of events, but it does boil down
A lot
to
of dispositions.
Yes.
Just not of it. It wasn't an event. It was a disposition. But I mean, it's very disturbing. But what's between the lines? Between the 50 traffic offenses, 25 bad check issuances, 7 failures to appear, 2 open container alcohol, 1 possession of drug paraphernalia, 1 violation of school compulsory law. I think if we added all of this up, 96 criminal dispositions. 96. How you're here today. What did you learn by those mistakes? You're here today. You're an adult and you're still making bad mistakes. A judge cannot be lenient with you. You cost everybody. You are a one-person crime wave. After 96 times you have had to go deal with crimes in various courts, from felony courts to misdemeanor to Class C misdemeanor courts. You would have gotten the message, and you never have. You just are a career criminal. You're the very essence of a career criminal. And I wish you wouldn't do that. Thou shalt not steal. You've heard of that one. I just wish you'd have changed your ways. But like I said, you've been doing this for 30 years. 30 years. Okay.
Judge, can I get some time to get my stuff in order and go to my doctor to get my vaccine?
No, ma'am, not under this situation. The jail is going to be I'm going to give you a chance during the Christmas season to go out and steal more stuff. I don't think so. Well, you've always done that. You've done that for 30 years, 97 times now.
It's tickets, traffic violations. So please. I got my grandkids living with me.
Ma'am, my God. I've got children. I've got grandchildren. 97th time, my gosh.
It's like all them times it's like tickets and
Ma'am, they were all crimes that you were found guilty of. They were all crimes. All of them were crimes. That is all. And make sure that you inform the jail about your health needs so that they can get the proper medication for you. That is all. Thank you.
Man, let's go. Let's go.
If you think this lady was the worst, wait until you hear what the next person did to his family.
Are you married to this lady?
Yes, sir.
Oh.
Standing before Judge Stevens is defendant Lynn LaSalle, who's being charged with a case of domestic battery. He's awaiting the verdict of the case, which will possibly be a sentence not less than 2 years, but not more than 5 years or probation.
I guess we're looking at no less than 2 nor more than 5 years in prison.
However, things are not looking very well for him,
This is the 3rd female that you've assaulted.
especially after Judge Stevens reiterated the horrible things he did to his partner and their children.
The complainant had a large bleeding scratch on her right lower arm and also multiple red marks and slight bruising on her face and neck.
After a couple more pleading, Judge Stevens handed down the verdict, finding the defendant guilty of 3rd-degree felony. He's expected to serve 5 years in prison.
LaSalle, you're Mr. LaSalle? Come on. Earlier in this case, the defendant entered a plea of guilty in this case. The agreement in this case is that whatever sentence shall not exceed a cap of 5 years in prison. So I guess we're looking at no less than 2 nor more than 5 years in prison. I guess deferred or unadjudicated probation is an option. Regular probation, I guess, is an option. This isn't the first assault on this list. You pleaded guilty, I presume, but you were convicted, placed on regular probation in 2019 for, assaulting Jacqueline Frank, the same complainant here. by scratching her face with your hands. And at the time, there was family. And I'm looking here that probable cause affidavit was again communicating with the defendant, leaving work, advising him she was coming to get her daughter. LaSalle kept telling her he was bringing her. Found LaSalle in the parking garage of the hospital. LaSalle appeared intoxicated, used his right arm to wrap around her neck and telling her to shut up, then let her go. She attempted to grab her child. He began to claw at her face and eyes, kept swinging at her with his fists, but missed due to his intoxication. The complainant had a large bleeding scratch on her right lower arm and also multiple red marks and slight bruising on her face and neck. Are you married to this lady?
Yes, sir.
Okay. I've been in a relationship for 40 plus years. I don't go scratching and punching and threatening. That they want a relationship that's peaceful. But you make this a living hell for this poor lady. Grasps her by the hair, drags her, causing her to scrape her arms and legs. Well, that almost seems familiar. Held her down in the parking lot by applying pressure to the back of her head, causing injury to her face, beating the truck and shouting at their daughter. This says Idmat Lau came to her home on Harding Drive, began beating on her truck window and shouting at their daughter, reached in the window of her vehicle and grabbed her by the hair. When I'm through, you can speak, but you push around girls. I don't like that. That's, you interrupted me again. You're a bully. You like to have it dominating your way. Criminal history, picking on guys. I see a possession of marijuana, possession of controlled substance, driving while intoxicated. That was above 0.15. You have no self-discipline. There's the assault, disorderly conduct, failure to appear, 4 public intoxications, criminal mischief, placed on 2 years deferred or unadjudicated. Pull that up, please. That felony. You just don't know the meaning of love, do you? No, you don't. It has nothing to do with violence. But this is the 3rd female that you've assaulted.
She's never done anything, but then she turns around and writes something like that. I don't understand it because we saw what happened between both of them. And then when I talked to her, it wasn't, he's no good. He needs to be locked up. It's, when do I get to see my daughter? I mean, I want to see her, or we have to come to some arrangements, or that's what I want is something that I can. And you do. You shake your head saying that's not correcting any problems. And
I've seen it. We've seen it over and over again. Yeah. It's victims have lost trust with the way the system works, especially in family instances. They don't know who to trust anymore. This is the 2nd time he's assaulted her. She's going, "What's the system doing to help me keep from being dragged around and my throat choked?" You ought to be the poster child for breaking up families. I now find you guilty beyond a reasonable doubt of this 3rd-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years.
From one violent young punk to the other, Judge Stevens is ready to show these kids that their bad actions come with consequences.
You don't see anything terribly harmful.
This young man is facing possible jail time after he was charged with holding a 3-year-old child at gunpoint and injuring another person.
The child, like I said, is my nephew. And I would never
So that's okay to shoot at the child?
No, like I said, it was self-defense.
While it was already surprising, to say the least, that he was given a chance at probation after pleading guilty, Judge Stevens decided he was better behind bars and granted the motion to revoke his unequivocal probation. At the same time, he was found guilty beyond reasonable doubt of aggravated assault and was sentenced to 10 years in prison.
Catario Richard Richardson, is that you?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney. You were placed on 10 years deferred or unadjudicated probation for aggravated assault causing serious bodily injury, a 2nd-degree felony. Is that true?
Yes, sir.
Number 1, state you failed to report to the Jefferson County Probation Office for the months of April 2023 and May of 2023 in violation of your probation order. Is that true or untrue?
Yes, sir.
Was he a absconder or did he? How long was he gone?
He only reported on his initial visit, which was March 1st of this year, and after that, he went gone.
Never came back?
Never.
Is that true?
Yes.
The first one, and then that was it? You had 10 years of probation. Oh, it just wasn't convenient for you?
Sir.
Why did you walk off the job?
I wanted to report, but at the time
Your feet didn't want you to be there.
No, sir.
You committed the offense of evading. 5, you committed the offense of evading detention on or about November 25th, 2023 in Jefferson County, Texas, against the peace and dignity of the state in violation of your probation order. Is that true?
Sir.
Huh?
Yes, sir.
Are you pleading true to that voluntarily and because it is true? Can be revoked. You can now be found guilty, and you are looking at no less than 2 nor more than 20 years confinement in prison. Plus whatever prison time you serve, you cannot be paroled until 1/2 the time of service has occurred, because there's a deadly weapon, namely a firearm, that was used in the commission of this aggravated assault. You shot somebody. Do you understand all of it? The victim had been shot multiple times and was transported to the hospital for treatment. The victim stated while she was placing her child in her vehicle, a red Mercedes SUV occupied by you and 2 others. Don't shake your head. You and 2 others pulled up and began to fire rounds into the vehicle. Multiple shell casings were located at the scene. The victim, I think, was a person who looks like they were 20 years old. How old was the child again? The child had been taken at gunpoint from her. The front passenger of the vehicle was you. You were in possession of a Taurus 9mm firearm. I guess it was a miracle that a little child was not killed, that somebody else was shot. Do you understand how serious this is?
Yes, sir, but the child was nowhere in the vehicle because when we pulled up.
So that's okay to shoot around town?
No, I'm saying
Shoot a vehicle.
you allow me a second chance. I do want to complete papers, and I will complete papers. Like I said, I made a mistake, and the child, like I said, is my nephew, and I would never.
So that's okay to shoot at the child?
No, like I said, it was self-defense.
You were hereby found guilty of that offense. I now sentence you to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. A deadly weapon, namely a firearm, will be placed on the judgment, and it will be rendered affirmative finding on the judgment that is found so based upon the evidence. You understand what has happened to those?
Yes, sir.
That is all.
As if holding a child at gunpoint is not bad enough, this next person literally opened fire in a crowded place, and Judge Stevens is ready to give him what he deserves.
State of Texas versus Jose Gabriel Cortez. You and Mr. Cortez?
Yes.
Identified as Jose Gabriel Cortez, this teenager did something unimaginable and is being charged with second-degree felony aggravated assault, which might land him 2 to 20 years in prison. However, the prosecutor had a different plan and tried to defer the charges after the defendant already pleaded guilty.
The reality is both these victims are lucky to be alive. Case we dismissed, that victim did not suffer serious bodily injury. They suffered bodily injury.
Luckily, Judge Stevens saw through his plan and showed them that in his court, justice shall be served.
I can place you in jail up to 180 days. And we call 22-39246, the state of Texas versus Jose Gabriel Cortez. You and Mr. Cortez?
Yes, sir.
Present with Mr. Kelly, your attorney, and the state's attorney does the defendant. And it alleges that on or about February 10th, 2022 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault. Do you understand what you're charged with?
Yes, sir.
If convicted of a second-degree felony such as this, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years, I think. There will be terms and conditions of probation which are normal and customary for this. You have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I mean, somebody got shot, right?
Yes, sir.
That
The
normally you pay a price with me when you're shooting people, because you can kill people that way. And
the reality is both these victims are lucky to be alive. Case we dismissed, that victim did not suffer serious bodily injury. They suffered bodily injury.
shooting into a crowd at folks
Judge, if you had.
is no way to handle disagreement or issues. We send a message, what we do. Is that what we do? People are going to go out, and especially during the Christmas holidays, and get in differences, shoot somebody and say, I hope I fall on Judge Stevens because he's going to let me defer. And I'm not going to have to pay a price of going to jail as a condition of probation. We're using a deadly weapon to shoot people. That is a price, something different from where somebody may be placed on 10 years deferred for stealing merchandise from the store.
Judge, it is all that serious. but we've weighed out the circumstances, including the defendant's age and the information that I told you
He
has
knows
been shared
better.
with us by the defense. And I am asking that you move forward and accept this deal.
I'm accepting the deal. What I'm talking about is a condition of probation where he goes to jail for up to 6 months.
I feel that that's appropriate.
We don't, Judge.
I can place you in jail up to 180 days. I am going, as a condition of probation, order you based upon these circumstances to serve 180 days in the county jail. And when can you begin that? You don't have to do it immediately.
Along with the court, give us, Judge.
After first year, beginning Friday. What's the first Friday after January 1, January 5? Can you write that down in there, please? Thank you. All right. And that will be an added condition. That's a message to you and anyone who used the gunplay to resolve issues. That's what I can do. And we're going to put people in jail who use violence. It's far too often used instead of civilized behavior. Okay, go see that lady. Thank you.
This next person will make your blood boil.
The defendant then grabs her, pulls a gun, sticks it to her head, told her he would kill her, and hit her in her stomach.
Even Judge Stevens wasn't able to hold his emotions after he heard what he did. The defendant is being charged with aggravated assault and possession of firearms and is currently trying to negotiate the amount of his bond. This is where Judge Stevens was taken aback. After hearing the amount the defendant was proposing, the judge was clearly not having it.
It's enhanced to, correct me if I'm wrong, no less than 15.
That one, Your Honor, they're not in sequence, so it pushes it up.
One level.
And pointed out how $70,000 worth of bond is woefully inadequate for the offenses the defendant committed.
Who's up? Who's up? Anybody? 3 cases are called 23 CR 110, first degree felony, aggravated assault, family violence.
Your Honor, there's 2 cases pending.
I'm not through. 23 CR 120. We're gonna work through these here. 3rd degree felony, an indictment, a 3rd degree felony, unlawful possession of a firearm by a felon. That case, stand by. As the previous case, 1 or more prior felony convictions are alleged. So this aggravated assault in 110, it's enhanced to, correct me if I'm wrong, no less than 15.
That one, Your Honor, they're not in sequence, so it pushes it up.
One level. It's a 1st degree felony in paragraph 1 with prior felony convictions. It would enhance it to 15 to life.
Yes.
In 23 CR 120, it's a 3rd degree felony with a prior conviction. So that gets enhanced if found guilty of all of that to a 2nd degree felony punishment. And finally, 23 CR 340, aggravated assault, family violence. Again, all of these are on the same date. It looks like on or about February 8th. You have a 2nd degree felony punishment and a 1st degree felony punishment, unlawful possession of a firearm by a felon, and family assault. The victim says to the defendant she was pregnant. The defendant then grabs her, pulls a gun, sticks it to her head, told her he would kill her, and hit her in her stomach. It was a revolver. Police show up. She has bruising on her right upper arm, redness to her shoulder, as well as left upper arm. Then it was located and arrested. A silver revolver with a wooden grip was located in the defendant's closet, bedroom underneath some clothes. It was a loaded Taurus 38 caliber revolver. So he was booked in for unlawful possession of a firearm by a felon because he has 2 prior felony convictions. He will be placed on home confinement, not the victim's home or the complainant's home, some other place that you are going to live. And you must have a GPS and can only leave home for certain necessities that the court would describe and spell out when and if you are bonded out. Let's set this for trial. Defendant is ineligible for probation. All right.
Last but not least, this next person will reap what he sowed after he appeared with no remorse about the disgusting thing he did to his own child.
Distributed pornography of your child?
That's his daughter. That is his adult daughter, and there is absolutely photos and videos.
Judge Stevens put this man in his proper place after the defendant's attorney had the audacity to ask for probation for his client.
That being said, we're asking for the court to give him deferred probation in this matter.
But guess what? He asked the same before the wrong court because Judge Stevens will not allow this man to commit another offense and decided that the man is guilty beyond reasonable doubt for child pornography and is expected to serve 10 years in prison for each case that he committed.
Was looking at a cap, no less than 2 nor more than 10 years confinement on each case. And this is to run concurrently, correct?
Yes, sir. I mean, the first thing that I'd like to point out is the court's aware that he has a limited criminal history. I think there's one misdemeanor case. Then he's never had a felony. This is the only felony he's ever charged with. That being said, we're asking for the court to give him deferred probation in this matter.
To refer to possessing child pornography, not just lewd images of children, which were a handful of the images that he had. Most of these were images and videos of children being sexually assaulted repeatedly. And the defendant's attitude about it is, I'm sorry somebody took photos of them without their permission. That's what he said in the PSI. There's no recognition from him about really the harm to these kids. It feels like very much the, I'm not sorry I did it, I'm sorry I got caught kind of attitude. He would send me photos, I would send them back. Not all were of sexual content. I did not realize it was still there. I thought I had deleted it. That's his attitude about it is that, but he didn't just not delete them off Facebook. These were on his cell phone. This Herman man was not the only person he was communicating with. These are charges for promotion of child pornography because he was sending them back and forth to Herman. Yes, sir, because they're different images depending on what's happening in the image or the video. Like the first one is sexual contact. That's going to be probably a child masturbating or touching themselves.
Is this true? Manufactured and distributed pornography of your child?
No, sir.
That's his daughter. That is his adult daughter. And there is absolutely photos and videos.
That's your child. Whether
That's not what the charge. I thought you were asking if that's one of the charges.
it's in the pre-sentence.
Right.
report.
I thought you were asking if it was a charge. No, she's, yeah,
He is
correct.
not charged with that because she is an adult.
Let's don't play hide and
I'm not playing hide and seek. I thought you asked.
Finish. Taylor Kitty is your child.
Yes, Your Honor.
There are 27 images and 28 videos of pornography of her. You're looking over here. Look at me. That's what's in the pre-sentence report that's nobody's objected to.
Nobody.
Is that right?
Yes, Your Honor, it is.
Who makes pornography of their own child, distributes it? You don't see anything terribly harmful, shameful,
Yes, I do,
low
Your Honor.
life about that, much less distributing to others and accepting child pornography of stranger children. What was the age?
She was over 18. I don't remember. I have no answer for that, Judge. I'm literally, I've got a disease and I don't know what to do about it.
Really? Whatever this disease is, you couldn't see that this is an immoral, satanic act to bring your child into the underworld of pornography, manufacture and then distribute it and promote that? You don't see this as being a horrendous, terrible.
Yes, I do. Yes, I do.
Your disease has been festering for years. And to this day, you don't have anything. You haven't done much about this disease. Female child, approximately 6 to 8 years of age, laying down on her back in what appears to be a gray blanket. The female child is wearing a yellow shirt, partially pulled up, and she is nude from the waist down. There is a nude adult male kneeling in front of the child with his mouth laid right over the top of the male child. The adult male's erect penis is observed touching the female child's genitals.
That's just sick.
That's a rape. In each of these cases, you have pleaded guilty voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There is sufficient evidence supporting your guilty pleas. In each of these cases, from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. I'm following this agreement. And when you were denied sentence to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years on each case, and these cases shall run concurrently as agreed upon by the parties. That is.
Thank you, Judge.
Sharp success.